I welcome you to this interview.
Thank you, Honorable Chief Justice.
Good morning. Good afternoon.
Good afternoon, Honorable Commissioner.
Isaac Ruto is my name, and also Vice Chair.
Thank you.
Your Honor, good afternoon. Jacqueline Ngutia, welcome.
Thank you.
Good afternoon, Honorable Kandet.
Good afternoon.
Zilani Caroline, karibu sana.
Thank you.
Good afternoon, Mheshimiwa. My name is Charity Kisotwa, Commissioner. You are welcome.
Thank you.
Good afternoon.
Good afternoon, Honorable Commissioner.
My name is Omwanza Ombati. Karibu.
Asante.
Good afternoon, Honorable Kandet.
Good afternoon, my lady.
Fatuma Sichale, karibu sana.
Asante.
Good afternoon, Mheshimiwa.
Good afternoon, Honorable Commissioner.
You're welcome. My name is Olwande Evelyn.
Thank you.
Yes, thank you very much, Honorable Commissioners, for that introduction. Honorable Kandet, you can begin by indicating to us your county and your ethnicity.
Thank you, Honorable Chief Justice. My county is Narok. I'm Maasai.
Very well. We'll start this interview, which we like to make a form of a conversation so that you can relax and engage with us and we get the best out of you. Now, you can tell us what is your view of a judge of the High Court. If you were to paint a picture of a judge of the High Court who is an ideal High Court judge. And in that frame, then you can tell us how you fit in that frame, bringing in your experience, your knowledge, your expertise. Tell us that, and then we'll move to the next question.
Thank you very much, Honorable Chief Justice, and thank you, Honorable Commissioners, for having me this afternoon. An ideal judge to me is one that keeps to his oath of office and also the Judicial Code of Conduct for Judges. I would want to start by saying that an ideal judge is one who diligently serves Kenyans, noting that this is a position of service. Secondly, an ideal judge is one who would impartially do justice and also do justice in accordance with the Constitution. And in so doing, an ideal judge would do this job without fear and also without favor. That speaks to the courage of a judge. An ideal judge also is one who is going to be competent. And when I talk about competence, Honorable Chief Justice, I am looking at the quality of the work of a judge. So if you look at a judgment of a judge, does it show or demonstrate that the judge has the knowledge of the law and also the Constitution to make that judge a judge who can do justice to the people before that judge? Thirdly, Honorable Chief Justice, a judge ought to be fair in the performance of their duties to ensure that parties who appear before that judge are treated equally and given an opportunity to present their cases. An ideal judge is also one who chooses the path of integrity. An honest judge, one who is not engaged in fraud or any other action that will taint the office of the judge. An ideal judge is also independent, meaning that his decisions are made independently without any extraneous pressures of any kind. And so in brief, Honorable Chief Justice, I can pick those ones for now as the ideals and how an ideal judge would look like. Coming to myself, Honorable Chief Justice, I would want to say that I have been in the judiciary for the last 23 years, continuous and uninterrupted service to the people of Kenya. In those 23 years, I have been able to serve in different capacities. I started as a district magistrate 2 professional, served through the magistracy until the year 2012, when the leadership of the judiciary literally poached me from court. I was at Milimani Commercial Courts, and I was assigned to establish the office of the Registrar of the Magistrates Courts as we know it today. Then from there, I was appointed by this Honorable Commission in 2014 as the inaugural Registrar of the Industrial Court. That is how the court was known at that point. And Honorable Chief Justice, I return here today with a scorecard, which I will be persuading you to find has been very impressive, looking at where I found the Employment and Labor Relations Court in 2014 and the milestones that we have been able to record since then. Throughout my service, Honorable Chief Justice, I've been able to demonstrate that I'm competent, that I'm a person of integrity, that I've been independent in the performance of my duties, but most importantly, during my journey as a magistrate, I treated those who appeared before me, those are advocates, litigants, represented and unrepresented, with dignity, respect, and courtesy. And I've continued to do that throughout my service, Honorable Chief Justice. Lastly, as a registrar and someone who has been in judiciary management, I've gained skills, leadership skills, administrative skills, management skills, and have been also around during this transformation journey of the judiciary since the year 2012, during the development and also implementation of judiciary transformation blueprints, starting from JTF, Judiciary Transformation Framework, the Sustaining Judiciary Transformation, and I am now implementing the social transformation through access to justice. So I would say, Honorable Chief Justice, I'm an all-rounder. I have been able to be recognized again by the judiciary for my performance, and I actually forgot to say that a judge also must be a person who performs, so that if you have all these qualities and you don't perform in terms of your returns, then it may negate the progress made. So I was recognized last year and awarded a recognition award as the topmost consistent performing registrar in the judiciary, looking at the performance trends of registrars for the last 5 years. Towards the end of the year, I also received another award, a national award, the Order of the Grand Warrior of Kenya, for exemplary services to the Kenyan people in the judiciary. Thank you, Honorable Chief Justice.
I think we can leave that one there. We go to other areas of the interview.
Thank
Commissioner Mwanza.
Thank you, Chief Justice. Your Honor, if you look at Article 23A, I've read this article so many times, but sometimes I feel that it's not clear, and I just wanted to know what your mind is. It says that in applying a provision of the Bill of Rights, a court shall A, develop the law to the extent that it does not give effect to a right or a fundamental freedom. Yes, develop the law to the extent that it does not give effect to a right or a fundamental freedom. What's your understanding of this provision? Does it mean that the court reads into the law a fundamental right, or that the court does not at all develop the law?
Thank you, Honorable Commissioner, for that question. My understanding of this provision is that the court would develop the law to the extent that it does not give effect to a right or fundamental freedom. There could be a gap in the law, because in effect all fundamental rights and freedoms would need to be effected. But where the court finds that the law existing does not give effect to a right, then the court can be able to look at the law and provide a solution to fill that gap, if any.
Okay. Now, secondly, there are a special category of people or Kenyans who ordinarily come to court, children and vulnerable people and the elderly. Now you have a case in your court where children have been accused of committing murder. They are brought to your court, and in that court you have the parents and also the media. The court is packed and your office is small. Now, before they take plea, what would you do as a court in terms of the instructions under Article 53?
Thank you very much, Honorable Commissioner, for that question. First, I would want to know how old these children are to determine their criminal culpability. They are children under 12 years.
No, these are children. They are minors.
Yes.
They are minors. They are under 18.
Thank you. Then I can proceed.
Yes.
The first thing I would do is to ensure that the media does not take photographs of these children. They are entitled to their privacy. And I would also want to ensure that the court is actually cleared so that the children are not intimidated during the period that this matter will be in court.
Okay. And should the charge sheet in a criminal case whereby children are involved disclose the details, the particular details of the children?
No. Again, to keep to that privacy I referred to, it should not reveal the full names of the children. Just like their photographs should not be taken.
Okay.
Should be initial.
Okay. Let me give you one last scenario. So you have a matter that has been initiated by, say, the anti-corruption and economic crimes. In the anti-corruption and economic crimes division, there is a case that has been filed against a parent who is a public servant for asset recovery. And in that case, the public servant is named as party number 1 or party number A, and then party number B and C are children who a public servant has opened bank accounts for. So the case is brought before you to issue orders, preservation orders, and you notice that the party number A is a parent, party number B and C and D are accounts for children. How would you handle that?
Just a clarity, Honorable Commissioner.
Yes.
You're saying the charge sheet have the names of the children?
No, this is on the charge sheet. Now this is a seizure.
Yes.
An application under, for instance, asset recovery, where you have the first party as a parent, then the parent, it's alleged, opened accounts on behalf of the accounts in the name of the children, and some of the monies that is alleged to be proceeds is in those accounts. So when they come for preservation orders for you to preserve, party number A is the parent, party number B, C, D are children, and party number E is the spouse.
Mm-hmm.
Yes. So in view of the instructions under Article 53, what would you do to preserve, number 1, the interest to preserve the assets before they dissipate, but also more importantly, the right of the children to be heard?
Thank you. I'm not so familiar with that one. Let me try. First, I have to establish whether it is true that these accounts are registered or opened in the name of the children.
It's described that in the pleadings.
Yes.
Yes.
So I'll again go into issue about their privacy, that they're not disclosed. Yeah, so I think I may not attempt that one on that.
Yeah, but what do you do to you see, there is a public interest in preserving the assets, but also there is another important interest, because cases don't come in black and white, and you appreciate that.
Yes.
There is also another interest in actually protecting the children, and also, you know, their privacy, their integrity, and you know, and their general well-being, the paramount interest of the child.
Yes.
So how would the court intervene to have these interests protected? Because number one, the case is against the parent, but also there is a case against the children for purportedly holding money on behalf of the parent.
Well, thank you again.
And then the parent cannot stand in for the children. So what is the role of the court? Because the Supreme Court has said a lot of things about this, about how you navigate such issues.
Okay, I think I would first, if these accounts have been used to keep proceeds,
yes,
of crime, then you cannot say you will protect that account the way you do a normal account, where maybe a parent has kept savings for the child. So this account is also subject to investigations, and probably that's why they are in court. But what I would do is that the parent will take that responsibility.
No, the parent can't take the responsibility, because he's also part of is quote unquote an accused, or there's an allegation against him.
That's why.
So the interest of the parents might not sometimes be at the same. They might be at cross purposes with the children.
That's why I asked whether the names of the children are also revealed, or only the accounts that.
The names are revealed,
yes,
and actually they are described as children in the pleadings that are brought before you as a judge to preserve the assets. The names of the children are revealed, and also the account numbers, and they are also described as children.
Okay, let me check on that, then I'll come back to you.
Oh, you want to check that on that?
Not now, later.
All right. Thank you. I'll leave it at that.
Thank you, Honorable Chair. Honorable Kandet, 22 years, not a short period. You began as a district magistrate 2 professional?
Yes, my lady.
I thought that existed only during my time.
No, it was there in 2003. I think that was the last batch.
2003 was the last batch?
Yes.
Okay. Judicial review is a High Court-led supervisory process. I would like you to tell us the distinction, if any, between judicial review and an appeal, taking into consideration the purposes of each, the grounds, the remedies, as well as the procedure.
Thank you, my lady. I'll start with judicial review. This is in the realm of public law, where the High Court would be able to review the decision of an administrative body, and normally to look at the procedure that the body used when arriving at a decision. But an appeal normally is to a higher court, which is going to review any errors that may have been committed by the lower court, especially on matters of law, on also facts.
Private versus public. You talked about JR being a public. It reviews public decisions. What about the appeal?
The High Court also hears appeals arising from decisions of lower courts.
Both in the realm of public as well as private, correct?
Yes.
So that is one distinction that you've made. Let's proceed.
In judicial review, Honorable Judge, Commissioner, the court would be guided by the Fair Administrative Action Act to see whether the person was given an opportunity to be heard before that decision was arrived at.
Okay.
But on appeal, the procedure normally is that an appeal is filed in the higher court and to review the decision of the lower court again.
Okay.
Yes.
An appeal, you just file an appeal. What about a judicial review application?
It's not a petition.
A petition?
Yes.
Okay, I'm more concerned about the phases that it takes. It's two-pronged. What do you begin with in a judicial review matter?
Sorry?
What do you begin with in a judicial review matter?
If it's under Order 53, then one would want first to seek leave
to do what?
Seek leave to file.
Seek leave to file?
An appeal. Sorry, a review.
Does that leave operate as a stay, or you have to separately seek an order for stay?
You have to separately seek an order for stay.
In a JR?
Sorry?
In a JR?
I think the situation has now changed after the 2010 Constitution, where under the Fair Administrative Action Act, you do not need actually to seek leave. You can just file a judicial review, a petition.
So and if you're interested in getting leave, where do you get leave? I mean, sorry, if you're interested in getting stay, where do you get stay?
It's still a stay can be sought in the High Court.
So you file your judicial review application and you also file another one seeking leave?
No. You file an application for judicial review and seek a stay.
And seek a stay?
Yes.
You have an idea, but when you file an application seeking leave and you're granted, it operates as a stay. What about in an appeal?
In an appeal, you can seek a stay from the court that originally determined the matter, or you can seek a stay in the appellate court by your filing an application.
What remedies do you seek in a JR?
You'd seek remedies either to quash the decision of an administrative body.
So you're seeking an order for certiorari to quash. What else?
You can also seek an order of mandamus.
Yes, an order for mandamus. Finally? That one has skipped my... You can seek for an order of prohibition.
Yes.
What about in an appeal?
In an appeal, you can seek to set aside the judgment of the lower court.
And if you are not dissatisfied with part of the judgment, you're okay with part of the judgment?
Then to the extent to which you are dissatisfied, you can seek orders to that effect.
All right. Thank you. That's all, Honorable CJ.
Thank you, Honorable Chair. Good afternoon once again, Your Honor.
Good afternoon, Honorable
If
Commissioner.
you need, you can take water.
Yes, I should.
Thank you. I've gone through your sample writings. You submitted your thesis paper and decisions in civil matters. However, the most recent sample writing is of 2018. So maybe you can explain to us why you chose to submit to us not recent publications.
Thank you, Honorable Commissioner. I did not sit again once I was appointed as registrar, so I have not been in court to hear matters since I became registrar. So that is the earliest I could.
So you don't
access.
do reports, you don't do memoranda, and any other.
I do.
You don't do any writings.
I do a lot of writings, but they look more internal documents, or those which we write to stakeholders, board papers, or concept papers. So I thought those were more of institutional documents.
Okay, which you can as well get consent to submit them, so
Sorry?
that we know. You can as well get consent from your supervisor, so that you then submit to us, because it would be good for you to have shared very recent writings.
I agree, only that I had thought that my own writings would suffice.
Okay, so that said, you are able to identify issues clearly and apply legal principles in diverse subject areas. Your writings are coherent and the tone is professional. But I also took note that in the 4 sample writings, you did not make any reference to precedent. How will we tell that the final orders or your analysis was based on set legal principles or established legal principles and not just your own personal views?
Honorable Chief Justice, Honorable Commissioner, I have made reference to jurisprudence in one of the cases. I think Martin Jalale.
Proceed. Yeah, proceed.
Yeah. The only reason why I picked, especially that one of Caroline Nasimiu, is because my reasoning was tested in the High Court and also in the Court of Appeal. So I had wanted to demonstrate to the Commission that my writings have been tested in the higher courts, and that's why I picked those authorities, just to demonstrate that they have been tested by the superior courts.
Okay, yes. I'll have to review them further, because I didn't see any.
And I've also brought the High Court decision and that of the Court of Appeal
that affirmed your decisions.
That affirmed the decisions.
Okay. So your academic paper you wrote on judicial performance management, and among your recommendations were there is need to introduce qualitative parameters, and there was need to enhance stakeholder integration to improve accountability and service delivery. Has that changed? Because since you wrote your paper 2018 to now, there are so many things that have happened to improve the performance of judges and magistrates.
Yes, yes.
Including whether we've integrated stakeholder feedback.
Yes, that has changed. In terms of stakeholder engagement. The only bit that we're still struggling with is the qualitative aspect of gauging performance. We still do not have the parameters to look into the quality of the work, except perhaps where judgments are appealed. So you look at what the superior courts are saying and maybe form a trend and see whether judgments of a particular judicial officer are quality based on maybe the rate at which they are overturned or upheld in the superior courts. So far, we haven't gone that route. And I was making that recommendation based on what happens in other jurisdictions. I had referred to the system in Australia and also in New Jersey, where qualitative work of a judicial officer is measured through stakeholder engagement, where stakeholders are asked to comment about, let's say, a judge's temperament, and questionnaires are filled, and then the team that is doing performance will be able to take into account what people are saying about a particular judge, in addition to the quantitative aspect of the work of a judge. So we haven't really gone that route. Probably the team handling performance may want to consider how we can now also look at quality of the work instead of just numbers.
Okay. It is said that Judicial Service Commission often responds to pressure for speed and efficient delivery of services by increasing the number of judges and judicial officers. And on the other hand, the judiciary would then come up with rules and procedural layers, and also setting up committees to address the issue. Does increasing number of judges necessarily improve judicial efficiency? And could you give further details to your response? And what needs to be done to improve efficiency now that you sit as a registrar?
Thank you, Commissioner. The issue of numbers has been there before, but it's not the only reason why that can improve on efficiency. But of course, we have had lower numbers in all cadres, judges, judicial officers, and staff, and we need the numbers for purposes of performing the work. But it is not the only reason, because once the work is done, then of course there'll be numbers, but without really work. So I think if we are to improve on our work methods, to make use of the resources that we have in terms of case management, in terms of putting more hours for purposes of working and improving our operational efficiencies, then we should be able to handle the work. It is not numbers, because you may also have numbers, and then again the work does not move. So numbers alone will not guarantee that there will be efficiency. So it's all about using our resources like case management, ICT, in terms of improving our efficiencies, and then that way you can say that numbers may not be the only consideration.
Okay. Lastly, you say you come from Narok, and I know parts of Narok are under the Community Land Act and other parts of the country. Can a person lay a claim of matrimonial property in a community land setup? If yes, if no, give reasons to your question, to your answer.
You asked whether a person can lay
claim of matrimonial property in a community land.
No.
Okay, thank you. Thank you, Chairperson.
Thank you, Chair. Good afternoon once again, Mheshimiwa.
Good afternoon.
Now, picking still on the question of case management, why do we do pre-trials?
We do pre-trials to ensure that we sort out preliminary issues before the matter comes for hearing, so that by the time the matter comes for hearing, there will be no room for adjournments, because we'll have sorted out many of the issues, like for instance the agreed issues. You can also have parties look at the issues and see what is contested, what is not contested, for purposes of maybe referral to DR, and also to exchange documents and agree on what need to be produced, just to ensure that by the time the matter is fixed for hearing, there'll be less adjournments.
Okay, you mentioned ADR. What forms of ADR do you know?
ADR, we have conciliation, we have mediation and arbitration, and other traditional justice resolution mechanisms.
Okay, what is the main difference between mediation and arbitration as modes of ADR? Mediation
normally involves a neutral party bringing parties together so that they can be able to agree on actually, so the solution to the problem would be coming from the parties. So you just need a mediator to bring them together and give them an environment to be able to agree. But on arbitration, the parties would agree to allow an arbitrator to arbitrate on the dispute, and the decision of the arbitrator is the one that's going to be in use. The parties will not be part of the decision. They'll just present their case and the mediator separately write an award.
Okay. So suppose you are carrying out a pretrial in a succession case. One of the reasons why we do pretrial also is to dispense with interlocutory matters. So in the course of a succession case, there's an application before you for a grant ad colligenda bona. And in the supporting affidavit, they are saying the deceased left behind children, and we need school fees. The children have been thrown out of school, there's money in the bank account, and we want a grant ad colligenda bona to access the money to pay fees. Would you grant that order?
Yes, I would grant, just for that purpose of withdrawing monies to pay school fees.
When do we give a grant ad colligenda bona? For what purpose do we give a grant ad colligenda bona?
I think for purposes of collecting and preserving the estate.
So if you utilize part of the estate, is that collecting and preserving?
Well, that I may have missed that one.
Yes.
Yes.
Yes. So for grant ad colligenda bona, you do not utilize or dispense with whatever is in the estate. Okay. Looking at your performance, I don't know if you've seen your performance report from DISPO.
I haven't seen it.
I just want to say here that what you've said about yourself in the introductory statements is quite true. The report we have here from DISPO is that 2021, 22, 22, 23, 23, 24, you've maintained consistency in terms of getting a score of 100%, which is very good performance, and that is quite commendable, and that this has gone on for the last 5 years. So I commend you for that, and I wish you well. Thank you, my lady.
Thank you.
Thank you very much, Honorable Chair, and welcome again, Mheshimiwa.
Thank you.
So you've been more on administrative duties, eh?
Yes.
Could you tell us how you will reconcile the right to a fair hearing with the need to dispose of cases expeditiously with limited resources?
Maybe you can come up again.
The right to fair hearing, could you tell us, or could you reconcile the right to a fair hearing with the need to dispose cases expeditiously, considering that you have limited resources? How do you organize your matters?
Thank you, Honorable Commissioner, for that question. I think there is need to expedite hearing of matters, noting the available resources. But even as we do that, we need to ensure that parties get a fair hearing. For instance, I can give an example. When we do service weeks to ensure that matters that have been in the system are cleared, there's always need to ensure that we involve the parties by giving them notices of these matters, so that we don't end up clearing matters but the parties were not involved. Therefore, we'll have cleared matters, but you'll find that parties have not been heard. And yes, so that's what I would say about the right to a fair hearing.
Okay. Now, in your view, what are some of the issues facing judiciary today that undermine public confidence, and what should the judiciary do to improve the public confidence?
One I would say is high case backlog that is still high, meaning therefore that matters are not leaving the system as quickly as they come. So when parties file their cases and they remain in the system for a very long time, then they'll start to perceive that the judiciary is not working for them. And when we then put into place a system to be able to clear case backlog, for instance, so that parties are current in getting dates in court, then the public confidence will go up. It's also the perception of corruption within the judiciary. There's a lot of information that people need to get out there about the workings of the judiciary. So if they are sensitized, you'll be able to understand why some things happen the way they do, because lack of information sometimes may make parties lose confidence in the system.
So what steps would you take to ensure that your court station is a corruption-free zone?
First, what we have done, because this is something that we have been doing, is to keep on training our staff on the dangers of corruption. We have also partnered with other institutions like the Anti-Corruption Commission to train our staff in terms of prevention of corruption within the institution. And we have also held open days where we explain our processes to parties who come before us, and then to that extent, therefore, we're able to, create awareness.
Okay.
Yes.
Now, finally, what do you think your colleagues or the stakeholders say about you?
Well, I wouldn't know what they will say, but in terms of my work ethics, for those who have worked closely with me, they know that I'm thorough in the performance of my duties. And so sometimes I'm a bit firm just to ensure that work is completed within timelines. Okay.
That's correct. No integrity issues were raised against you. They say that you are a good administrator, you are organized and reliable, is an outgoing person, and maintain an open door policy, consults widely.
Thank you.
Thank you. I wish you all the best.
Thank you.
Thank you, Honorable CJ. Honorable Kandet, a few questions from me. You've been majorly on administrative duties, and therefore I know you've interacted quite a bit with staff. What would you say you've done differently that sets you apart from all the other applicants when it comes to management of people in your station?
Thank you, Honorable Commissioner. What I've done, especially looking at the staff that are working under me, I have staff over 100 of them across the country manning our courts, including deputy registrars. One thing that I've done is that I have trained them. We meet once a year with all the staff of the Employment and Labor Relations Court. We bring together different stakeholders to speak to them, and so I have built capacity of staff. Secondly, as a court, we always consult everyone in the station, so that as management, we just don't take decisions. So staff own up to what is happening within the station, because we get feedback through staff meetings. And so they own up on what is happening in the stations.
Okay. Flexi working arrangements. What do you think about it, and do you think it can work in the judiciary?
Well, there will be need to maybe develop policy around that particular area. It should be something new, and but I also appreciate that it is something that is going to be inevitable going forward, where people would be working remotely, but there has to be a policy to regulate it, especially on reports, so that if someone is working elsewhere, so they don't report physically to work, then how do you monitor the reports? So, I mean, how do you monitor that particular area so that you can have reports to ensure that they are working, they're not doing other things. But it's something that with proper regulation, it will be inevitable going forward.
Okay.
Yes.
There are times you may want to initiate changes in your station if you're successful. How would you manage change resistance?
Like I said, you have to have buy-in from everyone. And so you really need to explain to the staff the kind of change that you want to introduce, explain the importance of that change and how it's going to impact not only on the work but also on the people that you're leading. So you may need to come up with programs to train, to make them aware and appreciate the need for that change so that you do not walk alone during that process.
So other than training and getting buy-in, any other ways?
That's what I would think of now.
You didn't think of regular feedback and communication?
Well, that's also important.
Okay. Finally, from me, is there anything you do in terms of community service? If so, what?
Yes, I would look at it in two fronts. As a court, we have CSR activities. We now have a flagship project. We call it the Employment and Labor Relations Court Annual Symposium and Exhibition. And as a pre-symposium activity every year, as a court, that is the judges and the staff of the court, we normally have one CSR activities. For the last 3 years, we have visited Kenyatta National Hospital, the Children Ward. We have gone to the Nairobi Remand Home, Children Remand Home, and also a children's home. So we do it at a court level where we have, as a pre-symposium activity, depending on the theme of the symposium, we always do CSR, and it's something that we do on an annual basis. At a personal level, I am part of the community where I come from. I am always part of them in terms of the happenings there. I support some children. I wouldn't want to mention them, that at least I have 2 boys whom I rescued, as they were herding cattle, and I took them to school. And so I would just say the rest now would just be what I do as a human being, as part of the community, and also in church.
All right.
Yes.
Thank you, and I wish you well.
Thank you.
Yes, I hope you are not tired yet.
Not yet.
Yeah, we are coming to the close. Now, can you tell us the 2 guiding principles in public finance?
Thank you, Honorable Vice Chair. One would be the equitable distribution of resources, and the other one will be the efficient use of those resources, and that will also bring in transparency and accountability in terms of the use of the resources.
Name the types of revenue that the judiciary collects and how these are accounted for.
Thank you very much. The judiciary collects revenue by way of fines that are imposed when the criminal cases conclude and a court imposes a fine. Again, we have what we call forfeitures that also would form part of public revenue. In terms of accounting for this revenue, they are all accounted through the Office of the Chief Registrar of the Judiciary because they go to the National Treasury.
Thank you and have a good day.
Yes, thank you very much, Honourable Commissioners. I think this is bringing us almost to the close of this interaction with Mheshimiwa. Just tell me in closing, what do you think is the existential threat to the judiciary? What is the main threat that the judiciary is facing today?
Thank you, Honorable Chief Justice. I think The main threat that the judiciary is facing is the perception of corruption in the corridors of justice that has been there for a very, very long time, so that there are people who don't believe that they can come and get justice without necessarily influencing those who have an opportunity to serve them. And so that is one. The other one would be the financial bit of it, where the judiciary is still grappling with lower allocations to be able to meet its operational and infrastructural needs, to be able to create an environment that would accommodate judges and judicial officers.
Okay, how do you think you should deal with it as a judge of the High Court, because you must protect the institution?
Well, with regard to issues around corruption, I think I'll lead by example by ensuring that myself and those who work under me are people of integrity.
Are you implementing the integrity committee in your courts?
Yes, we have established integrity committees in every of our courts, and they are all operational and they are running.
Okay.
Yes.
Do you receive feedback?
We have been having meetings from for members of these committees. So far, the members are giving their feedback, but then we're trying to focus on capacity building so that they can be able to understand this mandate.
Okay.
Yes.
Very well. I think this brings us to the end of this very robust engagement with you, Honorable Kandet. But we always give a candidate an opportunity also to engage us. So the floor is now yours.
Thank you very much, Honorable Chief Justice, and thank you, Honorable Commissioners, for having me for this interview this afternoon. I do not have any question to the panel, but I want to thank you once again. But also on behalf of the Employment and Labor Relations Court, thank you for elevating 4 of our judges to the Court of Appeal the other day. We are still celebrating, but I know in the fullness of time we'll feel that dent because the court has done very well in terms of performance, and when you have 4 judges gone now, definitely I know with the increasing number of appeals coming from the magistracy to the Employment and Labor Relations Court, we may need again more judges to be able to keep those gains. Thank you.
By the way, how many cases do you have at ERRC?
The case backlog currently is about, I think it's about 7,000 cases.
7,000 cases.
Yes.
That divided by
17 now.
17 now gives us a workload of how many per judge?
It's around 7,000.
Yes, about 400.
Yes, about 400.
Yeah. So all you need are your form back.
Or more. What happened, Honorable Chief Justice, is that magistrates of the rank of SRM and above have jurisdiction to handle employment and labor relations matters. Those matters are spread across the country. And since they started not long time ago, it will reach a point when these appeals are now coming. And when you only have 17 judges in the whole country to handle that, then it will be a challenge. For now, they can handle. But I think with time, those appeals, and if you look at actually the appeals division in Nairobi, it is picking up very fast following filings of those cases. The lower court in Nairobi has about 6,000 cases, employment matters, which are, I think, active.
Very well.
Yes.
So thank you very much. We will get in touch with you when we complete the exercise. As you know, it's a very competitive one. We wish you all the best.
Thank you.
And encourage you to keep up the good work.
Thank you.
You are released.
Thank you.
Have a nice afternoon.
Thank you.